How do the yearly taxes work if you receive a home via a ladybird deed? Do they get put in the receiver's name or stay in the name of the gifter? All right, so I'm assuming we're talking about property taxes here, obviously. When you do a ladybird deed, the person who actually owns the property is simply granting it back to themselves, person or people, as what we call life estate grantees. Remember, the people who are gifting the property, they still have full rights in the property while they're alive and while they retain the property or own the property. So it's not an immediate change of ownership. It's not going into the what you call the receiver, right, or the beneficiary, the remainderment on the property. It's not going into their name immediately, and they don't have any immediate ownership rights. So while the original owners of the home retain their ownership rights, and they're the life estate grantees in the property, then they continue to pay property taxes, and exactly the same way they've been paying them. So if it's homestead property, like here in Florida, if it's homestead property and they have the 3% homestead tax cap, that just continues on. Nothing changes. There's no actual ownership change, so there's no reason to reassess the property for tax purposes when you do a ladybird deed. So while the original owners are still alive, still living in the home, they're just going to keep paying property taxes as they have been years prior. They'll continue doing that for the rest of their life. Now, when the last surviving life estate grantee, so the last surviving owner passes away, when that happens, at that point, the property does immediately transfer to whoever they listed on the property as the beneficiaries. The deed uses the term remainder man if it's just one beneficiary, remainder men if it's multiple, but that person, the person who is inheriting the property upon the death of the surviving owner, right? That person will then be responsible for property taxes moving forward. So here in Florida, when there is an ownership change, there will be a reassessment for property taxes. So at some point after that ownership changes, you are going to see a reassessment. The property taxes will then be due and payable by the new owner of the property, the person who was put on the deed as the beneficiary, and then they're going to, of course, be responsible for the taxes moving forward unless, of course, they sell the property. Now, one thing that I wanted to point out here that's really important, a couple things here with ladybird deeds, and I've mentioned this before, but one is the ownership does change upon the death of the surviving owner. So there's no immediate ownership change when you do this type of deed. The second thing, since we are talking about taxes, when the person who is inheriting the property inherits it, for their tax basis, what they would use to calculate taxes if they sell the property, they get to use that step up in basis. So they get to use the fair market value at the date of death rather than the value that whoever owned the home originally paid for. So we do see oftentimes if you are inheriting property and then selling it right away, there shouldn't really be capital gains tax involved. But there very well could be an increase in property taxes depending on the scenario at the time. But the good news is if you keep the property and you move into it, then you can actually apply for homestead, and then moving forward, you can also receive the benefit of the homestead cap. All right, I hope this helps.